It would have been better in attempting to spur action by a foreign government in coordinating law enforcement efforts with our government to have done so through proper channels. While the president certainly enjoys the power to do otherwise, there is consequence to that action, as we have now witnessed. After all, that is why we are all here.
Attorney Robert Ray, you see right there on the floor of the United States Senate, making the case defending President Trump before this impeachment trial. And Mr. Ray, fresh off those arguments, joins us right now. Thanks for being here.
Nice to be with you.
Let's take a look at your argument on the Senate floor on evidence. Take a look.
No amount of witness testimony, documents, high fives, fist bumps, signing pens, or otherwise are ever going to be sufficient to sustain this impeachment under the Democrats' own standard.
You say the evidence is not sufficient. Let's look at some of it, right?
Sure.
You have Ambassador Taylor and other employees of this administration saying, well, they are withholding assistance for help with the campaign. And the new Bolton book says that Trump himself demanded freezing the Ukraine aid until officials there help with the investigation into the Bidens. Is your core argument in this Senate trial that that is false, or it doesn't matter if it were true, it's still okay?
Let me say and put it this way. My view is, and this is just one person's view, the president is entirely permitted to withhold assistance temporarily to see what the Ukrainians do. And I think at best that's the import of what, even if you credit what is in a book that I haven't seen yet and don't know what it says, what would potentially come from Mr. Bolton. And that is to say, so long as aid is not conditioned with the Ukrainians on that matter and that issue, that there's nothing illegal about that and nothing, therefore, impeachable about that.
But if the aid is conditioned on getting the Biden probe, that's illegal?
Well, that's, we have talked about, that's fundamentally what is a quid pro quo. But the part that makes that condition corrupt is that would have been necessary for that to have been communicated directly to Ukraine. And they have denied that happened, that there was no pressure. And again, to reemphasize the point, there's nothing unlawful or impermissible about the president temporarily withholding assistance to see what the Ukrainians do.
Let's dig into this, because I could imagine some heads exploding with what you're saying. On the facts, which are contested, so there's more than one set of arguments,
right.
There are Trump administration officials who say the Ukrainians not only knew, but they were asking about it. And on the conditioning, we talk to people. Everyone has a public record. Mr. Starr, who you replaced in that office, has a public record.
Sure.
Here was you telling us about what would be illegal. Take a look.
What's illegal is expressly conditioning on it that only one will be done in exchange for the other.
Only one in exchange for the other. And the evidence, I know you're familiar with it, it was played in this Senate trial.
Right.
Donald Trump was asked, what do you want them to do? You referred to temporarily holding it up, but temporarily, that's the whole deal. The deal was what he wanted in return. And here he was on the White House lawn admitting his objective, his own words. Let's see that.
Mr. President, what exactly did you hope Zelensky would do about the Bidens after your phone call? Exactly.
Well, I would think that if they were honest about it, they'd start a major investigation into the Bidens.
And again, my point
is that a corrupt goal?
No, that's what's in the president's head and what it is he wanted, which seems to be essentially the essence of what Mr. Bolton would testify to if called as a witness. That isn't reflective of a corrupt and illegal quid pro quo that would lead to bribery. And as we've argued, and as Mr. Dershowitz has argued, and as frankly the entire president's defense team, even if you credit all of that, that's not going to be sufficient
so it's
to warrant
fine
to be abusive power.
It sounds like you're going
from office.
But it sounds like you're going farther than some of the other Trump lawyers. You're saying it's fine to demand a probe of a domestic rival?
Well, look, I addressed that issue during the course of my remarks to the Senate, and I have said that many of the senators have or potentially will conclude that the call was less than perfect. That's not the issue. The issue is whether or not the conduct is sufficient to warrant the president's removal from office.
But isn't this, let me press you on this, Robert. Isn't this the question, the corruption of the goal? Isn't this the question that when he says, I want you, foreign government, to go after my rival, that is the corrupt goal?
What he would like to see, in other words, as it was expressed in the New York Times article, is about what Donald Trump wants. Only to the extent that, as I said during my remarks, the conversation would have had to have been significantly different. It would have had to have been something like, listen, here's the deal. You're not getting foreign aid unless I get what I want. Now, that's another question. That never happened. And our position is that short of that, the conduct is not sufficient to constitute an abuse of power warranting the president's removal from office. And my point is, if you accept that proposition, no amount of witnesses or documents are ever going to change that. That's why witnesses are not necessary. And I believe on a bipartisan basis that senators can unite around that proposition.
Right. Well, and you may be hitting something that some Republican senators welcome.
I hope so.
That's your job. But I'm going to press you and give you time back. You're raising the bar. You're saying even if it's a potentially corrupt intent, even if it is a demand to go after rivals, even if it's election interference, as long as there wasn't an explicit demand of an exchange in the quid pro quo bribery, then you're good.
You reconstructed that a bit because that's the last part is what makes it corrupt. It's not the first part. Okay, it is only corrupt if there's clear and unmistakable evidence that there was an improper bargain for exchange. What the president would like to see the Ukrainians do is not illegal. And again, I'll go back to the original premise. If what the president did here was temporarily withhold aid in order to see what the Ukrainians would do, even if it's something that he would like done, as long as he doesn't condition the one on the other, that's not bribery.
It sounds like,
and it's not sufficient to warrant the president's removal from office.
This is an abuse of power charge. That's what's under debate. And it sounds like you're making an argument that attempt is not fully an abuse of power.
No,
that if he's unsuccessful because you waited out the Ukrainians, they didn't do what you wanted.
No. The point is the president, again, it has to be, the intent is important, as you suggest. And I acknowledge the proposition that obviously a not completed intent is not required under the law to constitute corruption. But this is not corruption because the president is entitled to withhold aid in order to see what the Ukrainians do. And
what if they do the bad thing? I mean, anyone listening, you have to understand, someone listening to this is going to think, okay, wait and see what they do. What if they do the bad thing? What if they announce the investigation to Biden's and then you give them the money because they did what you want? Isn't that the whole problem? That's the alleged abuse.
Yeah, but that's also why it's so uncertain. And I guess to get back to your point, while acknowledging that theoretically that could still be a problem, you have to understand also that your principal witnesses here, which would be the Ukrainians, have said that no pressure was applied. And moreover, the president denied emphatically both to Senator Ron Johnson and also to Ambassador Sondland that there was no quid pro quo.
Well, yeah, and I thought that was striking. I mentioned something that looked reasonable. Before I let you go, we have to get into something else. You mentioned honesty.
Yes.
Some of your co-counsel went to the Senate floor and said something that is historically false, that disagrees with precedent. They claim that abuse of power, which, as you know, as former independent counsel, and you replaced Ken Starr, and he knows because he pursued it, was an original article of impeachment against Richard Nixon and Bill Clinton. Everybody knows that. And yet, we see this newfound argument against it. For the benefit of viewers, let me play some of that, and then you get your time. Here was several lawyers arguing along those lines.
It is inconceivable that the framers would have intended so politically loaded and promiscuously deployed a term as abuse of power to be weaponized as a tool of impeachment.
Impeachments should be evaluated in terms of offenses against established law.
Violation of law necessary to sustain impeachment as an abuse of power.
Why go before those senators who know better and have the president's lawyers, and others went farther than you, Mr. Dershowitz, certainly the farthest, and tell them something that's historically false when we know abuse of power is impeachable? It happened in the last 2 impeachment probes.
Yes, because I think my answer to that is that abuse of power, and I'm not sure you'd necessarily ever want to exclude that as being potentially impeachable. When it has been done, it hasn't fared well. It has not enjoyed bipartisan support.
Let me hang you up right there. What you just said is more accurate. Again, this is for the public record. This matters. And you're in the middle of this trial. What you just said is more accurate than Professor Dershowitz. You said it can be impeachable, but you're arguing against it here. He said, on behalf of the President of the United States, that abuse of power itself is not impeachable, which is false.
I think you have to be careful about that, though, because there's been a lot of misunderstanding. Let me say what I think is hopefully the clearest and well-stated proposition about what is and what isn't impeachable. Well-founded articles of impeachment, which include references to the Constitution, the founder's intent, and significantly historical practice, are those that allege high crimes, things, treason, bribery, and things like that, okay, that also constitute an abuse of power, and in the context of a presidential impeachment, essentially are tantamount to a violation of the president's oath of office.
But you don't deny that the House Judiciary Committee did impeach President Nixon for abuse of power.
Well, it's a little tricky because it was tethered to the first article of impeachment, as I explained, which alleged a conspiracy to obstruct justice.
But again, I mean, I can read from it. It's the Article 3 against Nixon was abuse of power, as you say, in addition to other articles.
Article 2, I think. The third article was
with Clinton, you have
obstruction of Congress,
misuse and abuse of his high office, misuse and abuse of his high office against Clinton, which is what Ken Starr recommended, as he called it, the capstone article of impeachment against President Clinton, and you replaced him.
But that article of impeachment actually never made its way to the Senate trial. The only two that were there were related to obstruction of justice.
Right, and the fact that, again, this is so important because this all matters. The fact that someone might be acquitted of murder does not extinguish the fact that murder is a potential offense. And Professor Dershowitz has been telling the nation you can't impeach for abuse of power. It seems today that you're acknowledging there's more to it than that.
But it's always more to it because we also have President Gerald Ford's famous comment that essentially, impeachment is in the House of Representatives, whatever a majority of the House says that it is. But he also recognized, and I alluded to this as well during my remarks, that in connection with presidential impeachments, you got to be very careful because you're attempting to take out an entire branch of government. And with regard to presidents, it really truly does have to be treason, bribery, or emphasis on the word other, something like that. And my only point is that in the context of abuse of power, you better be really sure and really clear about that. Otherwise, what you have is a standardless impeachment. People need to understand that in order to be at that very high bar with a 2/3 necessary from the Senate to remove a president from office, abuse of power in the context of what the House managers have done here does not enjoy bipartisan support. And it's the reason why we're here now talking about this, where everyone acknowledges that the president is not going to be removed from office. And there's a reason for that.
Well, and Robert Ray, you're in the middle of this trial. You came here after presenting on the Senate floor. We wanted to press you on the issues and also give you time to make your case. So I appreciate you coming on.
No, it's always a pleasure. Thank you very much, Ari.
Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.